The Supreme Court will hear legal challenges to the Texas abortion law for the first time Monday. The Texas law stops abortions as early as 6 weeks into a pregnancy before most women know they are pregnant. It also allows anybody in the U.S. to sue someone who helps a woman get an abortion outside of the time frame. The two cases before the Supreme Court focus on the enforcement of the law and not necessarily abortion rights as a whole. I want to bring in Linda McClain. She is a law professor at Boston University. Linda, thank you so much for joining us. Will these arguments be all about standing and enforcement, or can we expect the Supreme Court to address abortion rights in these cases?
Thank you. These arguments should be about standing, but the parties' arguments about why there should be standing will touch on the fact that in the case of the U.S. government and the clinic providers, what Texas has done is foreclose a way to challenge an unconstitutional law that prevents women from getting access to abortion after 6 weeks. So inevitably, one of the reasons that they say they have standing is that this is an attempt to keep them from finding any way to challenge a law that inhibits the constitutional rights of pregnant people.
Now, the Supreme Court decided not to block the Texas abortion law before it went into effect. Is this any indication of how they will rule on the two lawsuits?
Well, that's a really good question, because in the case of the providers, even Chief Justice Roberts was in the dissent saying that it was wrong not to block that law pending challenge. But when the U.S. government brought a lawsuit, only Justice Sotomayor was in dissent from the court's decision not to block the law and not to undo the block of the law that the district court had put and then the Fifth Circuit overturned. So I think that we might get a sense of how seriously the court takes this based on what sort of signals they send about whether the staying in the federal district court injunction continues. Will they just keep letting this law have devastating consequences while they rule on this procedural issue or not? Thank you.
How do the two suits compare?
The first suit was brought by providers in Texas who were talking about the devastating impact that the Texas law had on their ability to provide abortion services and on pregnant persons' ability to get abortion services. The second lawsuit was brought by the U.S. government, the Department of Justice, saying that this was an unprecedented effort to inhibit people from exercising their constitutional rights, and that the U.S. government had to step in to vindicate a constitutional right, namely the right in Roe and Casey, and to protect against a tremendous burden on interstate commerce, where people are having to cross state lines to get abortion services because most people can no longer get them in a timely fashion in Texas. So in the U.S. case, the question is, can the federal government sue a state, right? And in the provider case, it's, can a provider bring a lawsuit to challenge this law in court, or has SB 8 effectively prevented anyone from challenging the law because it shifts it to private bounty hunters?
That being said, what will the Supreme Court's rulings mean for strict abortion laws in other states?
If 5 justices are willing to say that Texas can make this kind of law, there's a whole bunch of copycat laws that could go to an effect, and that would basically have the effect of eliminating most of the protection of Roe and Casey without the Supreme Court even having to formally overrule either case. If the court instead concludes that this Texas law goes too far by putting so much power into private citizens and cuts off the ability to challenge the violation of constitutional rights in court, then it means that people are probably going to look to Dobbs, which is coming up in December, to see what the court will do on the underlying merits of abortion law. Because the only issue on which the court is granted cert in this Texas case is this procedural question, right? Not the merits of the underlying 6-week restriction.
So the court is also hearing arguments over Mississippi's new abortion law in December. Do all these new cases indicate a willingness by the justices to overturn Roe v. Wade. You kind of just touched on it, but do you think overall we'll see an overturn?
Well, that's a complicated question, and I think after the court granted cert in the Dobbs case, that Mississippi added as an issue that they wanted the court to consider whether to overrule Roe. I mean, we know that on one count you could have 5 justices on the court who were prepared to overrule Roe. On the other hand, and the Chief Justice has been more concerned about stare decisis and not overruling precedent. And it's notable he was in the dissent when the court decided not to stay the Texas law. So what I think is that there is a way that one thing the court could do is say Roe is wrong. This belongs in the democratic process. There's no fundamental liberty of women to make this decision, and we're just going to return to the democratic process. Or the court, kind of like what they did in Casey, where they claimed they weren't overruling Roe and they were affirming its core holding, but then proceeded to really change the amount of regulation states could do. They could say, 16 weeks isn't an undue burden. I mean, most women know they're pregnant well before that. Over 90% of abortions take place in the first trimester. So we're not formally overruling Roe and Casey. We're just kind of reinterpreting what an undue burden is. And one reason they might be attracted to that is if they care about the political fallout, overruling Roe could really mobilize Democratic and blue state voters, whereas not overruling Roe could mobilize and energize conservative voters. So there's a lot of different variables about how this could come out in December. And we'll see clues of it, I think, in the oral argument. I'd like to say that Justice Coney Barrett, a lot of people have commented on how, even though she has made personal kind of statements and some public statements before she became a Supreme Court justice regarding Roe as wrong, when she had a chance in the Fulton case back in the summer to overrule a very controversial religious liberty precedent, she opted not to do so and got the ire of some of her conservative colleagues. So she may want to go slow and find some way to somehow claim that this law is consistent with Roe and Casey, even though, in my view, it certainly is not.
A lot of moving parts. Linda McClain, thank you.
Thank you.